All right, Missy,
false
I
imprisonment.
want you to stop talking, or you can go upstairs to the county. I'll be on in being in recess on Jackson will now be on the record in Johnson. That is case number 2024 TR 22, State versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
You're charged in speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge.
All right, guys, buckle up, because what you're about to witness is not just a courtroom moment. It's a full-blown collision between belief and reality. A man walks in, confident, unshaken, convinced the law does not apply to him. But sitting across from him, a judge who has seen it all and isn't playing games today. This isn't theory anymore. This is real life, real consequences. The courtroom is silent, tension already thick in the air. What starts as a routine hearing quickly spirals into something far more intense. Because today, someone is about to challenge the entire legal system. And the system, it's about to respond. This is where everything begins.
Option, you might be able to apply for diversion. That is where the attorney approves you for diversion. You would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty, and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges.
The judge begins calmly, laying out the charges. Nothing extreme at first glance. Speeding, no proof of insurance, standard violations, or so it seems. Fines, penalties, options. Everything explained clearly, step by step. The kind of explanation designed to make things simple, manageable. But here's the twist. This isn't a normal defendant. Instead of understanding, he resists. Instead of listening, he questions everything. Not just the charges, but the authority behind them. And right there, the tone of the entire courtroom shifts. This is no longer routine. This is resistance.
Need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you time.
I object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Now things take a sharp turn. The defendant doesn't just disagree. He challenges the foundation of the court itself. He demands clarification, not in a normal way, but in a way that disrupts the entire process. Words like jurisdiction and agreement echo through the room. He refuses to enter a plea, claiming he doesn't even recognize the authority questioning him. The judge stays composed, but you can feel the patience being tested. This isn't confusion anymore. This is defiance, a direct clash between personal belief and legal structure. And it's only getting worse.
State's bringing charges against me. Who is it? How did I injure the state?
This is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea.
I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in
I
stopping.
would like to also bring to
September
according to
27th.
USC 12203.
Deputy Miles.
And also
did you,
Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then, boom, the judge steps in. A not guilty plea is entered on his behalf. Standard procedure. But the defendant, he objects immediately. Loud, firm, relentless. He refuses to accept even that. At this point, it's clear. He's not here to cooperate. He's here to challenge, to argue, to push every boundary. The courtroom energy turns electric, almost explosive. Because now, it's not just about charges anymore. It's about control.
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right. So your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor, I
right,
also have a right to understand the nature of this. I have a right to understand the
all
nature
right.
of the cause.
If you don't want to listen to me, you can go to jail.
Then, boom, the judge steps in. A not guilty plea is entered on his behalf. Standard procedure. But the defendant, he objects immediately. Loud, firm, relentless. He refuses to accept even that. At this point, it's clear. He's not here to cooperate. He's here to challenge, to argue, to push every boundary. The courtroom energy turns electric, almost explosive. Because now, it's not just about charges anymore. It's about control.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
Now, the courtroom turns into a battlefield of words. The judge tries to move forward, setting dates, explaining rights. But the defendant keeps interrupting, repeating the same demand. I want to understand. Again, and again, and again. But here's the reality. He's already been told, multiple times, clearly, directly. Yet he refuses to accept it. This isn't about understanding anymore. It's about refusal.
Are you in, or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the.
The judge lays it all out one final time. Clear, precise, undeniable. The charges, the jurisdiction, the consequences. Everything. At this point, there's no confusion left, only rejection. The defendant stands his ground, repeating the same argument. But the courtroom has reached its limit. The system doesn't pause for belief. It moves forward regardless. And now, the judge gives him a choice. Walk out peacefully, or face immediate consequences. A simple choice, but a powerful one.
These charges being brought to me on the.
The state of Kansas has charged you with speeding 82 and a 65 and operating a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal.
But according to the Constitution, there are only two jurisdictions.
All right, we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with.
You give us any problems with it?
I'm not giving y'all a problem. I'm trying to.
So you have place you in handcuffs and one.
And just like that, the moment peaks. The defendant still pushes, still questions, still resists. But the judge, done entertaining it. The order is clear. The session is over. Officers step in, ready to act if needed. What started as a simple traffic case turned into a courtroom showdown, a powerful reminder. Belief does not override law. And in the end, reality always wins. This wasn't just a hearing. This was a lesson.